Does HIPAA protect my PTSD treatment records? If you are wondering whether the Health Insurance Portability and Accountability Act protects your PTSD treatment records, the answer is yes, but there are important details to consider. HIPAA is a federal law aimed at safeguarding your privacy and security regarding your protected health information, which includes mental health records related to PTSD treatment. Under HIPAA, healthcare providers are required to keep your treatment records confidential. They can only share this information under specific circumstances, typically requiring your consent or authorization. One key aspect of HIPAA is that your PTSD treatment records are classified as sensitive health information. This means that your healthcare providers cannot disclose your mental health information without your permission, except for specific purposes like treatment, payment, or healthcare operations. It is important to know that psychotherapy notes, which are detailed records your therapist keeps about your sessions, receive extra protection. Unlike other parts of your medical record, HIPAA mandates that you must give explicit authorization for these notes to be released. Providers have discretion over whether to share these notes with you, and in many cases, you do not automatically have the right to access them. This is intended to protect the therapeutic relationship and sensitive details discussed during therapy. HIPAA does allow for sharing your PTSD treatment information without your consent in limited situations. For instance, if another healthcare provider needs the information for your treatment, or if there is a serious and imminent threat to your safety or the safety of others, your information may be disclosed. For example, if a provider believes you are in danger, they may share information with family members or others who can help, even if you do not agree. Generally, you have the right to access your medical records, including most of your PTSD treatment records. However, psychotherapy notes are an exception, and providers can deny access to these notes without a formal review process. It is also worth noting that while HIPAA sets a federal standard for privacy protections, state laws may offer additional safeguards or conditions regarding the disclosure of mental health information. Providers often consider both state laws and HIPAA when deciding how to handle your PTSD treatment information. In legal situations, HIPAA permits the disclosure of your PTSD treatment records if there is a valid court order or subpoena. However, psychotherapy notes usually requiring specific authorization for releases. This means that while your records can be disclosed in legal proceedings under certain conditions, there are protections in place to prevent unnecessary exposure of sensitive details. In summary, HIPAA does provide protections for your PTSD treatment records by limiting unauthorized disclosures and requiring your consent for most uses outside of treatment and healthcare operations. Psychotherapy notes receive heightened protection and often requiring your explicit permission to be shared. Additionally, providers must consider state laws that may offer further privacy rights. These safeguards are crucial as they help create a safe environment for individuals to seek and continue treatment without fear of improper disclosure of sensitive information. This trust between patients and providers is essential for effective care in managing PTSD.